Good evening. I'd like to call to order Granby Zoning Board of Appeals meeting at 6:29. So we're about a minute early. I just want to remind everybody that we are currently being videoed and audio taped at this time. So please be aware of that. I would ask at this time, everybody, please take a moment and silence your phones for the respect of all parties here so that there are no interruptions. We don't have to stop as we go through this. Just also a gentle reminder, please to respect everybody here and the board. All questions must go through the Zoning Board of Appeals. At that time, we will determine how we'd like to direct that. Please do not speak out of term. If at any point you are asked to please stop talking, that'll be your one warning basically. After that, you will be asked to leave as we need to have a good proceedings. So please respect all. At this time, I'd like the board members to please state their name for the records.
Anthony Huerta.
Jeremy Carrier, Chair.
Ron Arup, member.
Kathleen Brenner, Vice Chair.
Brian O'Toole, Town Council.
So just a point of interest at the beginning of this meeting to remind everybody that today the Zoning Board of Appeals has done a site visit at the Granby Bow and Gun Club. So that way we could get a better perspective as to what we're discussing on that range. At this time, we're also going to discuss things openly that any of our board members may have questions of the gun club. So from that site visit, if any of the board members would please like to ask questions.
I think just for the group, I just wanted, I know we reviewed it while we were at the site, but just to share the boundaries for where the original shed, the lower shed is, and the proposed new shed, and the boundaries, and just confirming where the tree line was. I had asked that question, and I just, if you could share that, the tree line runs below the large hill. I guess would that be Bags Hill Road or Bags Hill? And because I did ask that question, just to get a sense of the boundaries. And I know you had shared from where the sheds were to the left and to the right. I had it reversed there. If you could share that, I think, give us a perspective.
From one point, it was, you want me up there, or you want me to sit here?
Just say your name,
Watson
please.
Johnson.
Thank you much.
Granby Club. Approximately 275 feet, I think it's on the plan that you had, to the closest butter corner.
From which,
From the upper.
fire unit?
Yep, and it's a little further from the upper, right? Am I right, 270 something?
Well, that's where there's a little confusion. That's why we're trying to figure that out.
Oh.
I actually do appreciate the site visit because
Thank you.
because some confusion of an upper or lower shooting area. I did not realize the elevation of what was called the upper. I always thought they meant upper is to higher further up on the range for a lot of it. So elevation is what upper was referring to. So just because on there I don't know, and from our visit, do we know what that elevation is over the top of the lower shooting area? Do we happen to know how many feet over the top of that would be for radiation?
I don't know, I guess maybe 50 tops, maybe? I don't think it's even that much.
30, okay. And could you just let me know from pictures and visiting what there are markers that are all down through the center of the ranges, what those identify for us?
Yellow markers
Yes.
identify separate shooting lines, so target locations. So you can tell by the letter how many feet that you're shooting at a certain number of yards or feet. And there's a target to the right of those yellow letters represent that target line, and then there are targets located to the right of those letters.
Thank you. And for the outside boundary lines, how is it designated for the public if they were to try to enter from a non-roadway, a non-street, they're coming from private property? How would that be designated to a private owner coming onto your property that was danger?
Portia?
Yeah, there's posted signs, approximately 30 to 50 feet apart.
Okay.
So, Marshall, you need to describe the fencing as well. You're talking posted signs?
Signage, yes.
Okay.
Sorry.
And now, does the signage just encompass the range, or does it
Yeah,
encompass the
they go
entire
up
property?
the left-hand side, across the back, and down the right.
So you're asking whether the signage
The whole
surrounds
property,
the
or
entire
just the
Range.
safety distance around the range, or is it or around the entire property?
Just the shooting area.
Okay. Because you do have power lines that kind of go adjacent, I know some are on your property, some are on other property. Do you have any type of a boundary marked off of there, say at the end of where that public access is for, or utility company access, sorry for the misspeak on that one, so that they know that there's area, is that already marked off?
Nothing that far back. I mean, it's pretty far to the power lines from the back half of it. I mean, it's probably a couple of hundred yards from there to there.
From the back of what, just so I
From,
have clarification?
I mean, where the power lines are to where
So from the bottom of
the
that
tree line
berm
out
up
back
the
there, it's
mountain?
gotta be a couple of hundred yards, like, to the power lines.
So what you're saying, from the bottom of the berm, roughly 200 yards up the mountain to the power line?
You're saying from where the trees start, going up the mountain?
Yes,
To the
yeah,
top
yeah.
of, to where the
Yeah.
power lines are, yeah.
Yeah, I've never walked it, but
Okay.
seeing, well, actually, who brought it up to me tonight, you could actually see one tower.
Yeah.
That's the first time I've ever seen it.
I had just
Any,
one quick thing. So I know I had mentioned water displacement from the roof, from the new structure, because it's not there. It's roughly, given the 16 by 50 is the size of the new shed, correct?
16 by 50.
So it's, I did some math, and I could be wrong, but it's roughly about 1,600 square feet of roofing. During a half-inch of rainfall, you're gonna get about 1,000 gallons of water. Where are you planning to displace that water during rainfall? I mean, I wouldn't want it going down the hill, obviously, because you have the road on Chicopee Street on one side. Where would
Right.
you propose to run off the water on the other way?
It could go into the wet that's down to looking forward, down to the right, down to the right-hand side.
Sure, some type of drainage underneath, then under the gravel?
Sure, we can
in
do
that
that,
way?
yeah.
I'm just
We could bring it
throwing
up
that out there,
front.
because it's a lot of water.
That's easy enough to do.
any other questions as you're thinking about that?
No, I appreciate
From the
it.
site visit?
Yeah, I appreciated having the opportunity, so I thank you, because it's helpful as, to see where the buildings are placed and to be able to make decisions. So, now, mine was just the questions in the boundary, in the back boundary where the tree line was, so, thank you.
Okay. Just a moment, please. At this time, I am gonna call forward, let me look at the name again here. Mike, yes, from Green Miles, Lipton, correct? And we do have on file your objection, which I'll let you read out after that if you would like. So if you'd please approach.
Yeah.
One second, John, beforehand. Ron, did you want to mention something about the office that Attorney McLaughlin's from? You had mentioned that perhaps.
Yeah, the only thing I've mentioned is, I know John Green from Army Reserve, and he was one of my commanding generals, just so everybody knows that I do know him.
Disclosure.
Okay.
We're not drinking friends or anything, I just know him, he was my commanding general, so.
Okay, thank you.
So again, yes, if you'll state your name and your firm.
Mr. Chairman?
Yes.
On behalf of the applicant, before this attorney goes, we would like to read our objection into the record, because we believe anything that he would say will taint this process, is out of order, is too late, it's litigation by surprise. This was filed yesterday. The hearing began last month. This is being filed not only mid-hearing, but the day before the very last day of the hearing, after the public comments have taken place, after everything has been submitted. We see it just moments before the hearing's over, when we have no chance to change our oral argument, nor a chance to research what he's provided. And it has a date that's a month off, that purports to have been filed in April. It was actually filed in May, yesterday. And to hear anything from this honorable counselor would be quite inappropriate, because just hearing it as in court will taint the process. It could change your mind, influence your view of the facts, influence your view of the law, and it's completely out of order. We would ask that we have the right to read our objection to what was filed prior to him going forward, so that there's a record, so that if you decide to go forward and hear what he has to say, we've made our record for appeal.
I have no objection to that.
Thank you. I forgot my glasses, so.
Oh, no problem, yeah,
Attorney
yeah.
Abelson will read it.
Okay. Do you want me to?
Actually, yes, if you could change seats for a moment, so that way, yes. Thank you.
On behalf of the applicant, the Granby Bow and Gun Club, we respectfully object to the submission of the memorandum, the untimely submission filed with the Granby Zoning Board of Appeals on May 6, 2019, which is erroneously dated April 6, 2019, by John McLaughlin Esquire, counsel for certain property owners, the range opponents. The range opponents oppose the club's right to use its property generally, as well as in connection with the pending application for special permits for 2 shooter sheds on the club's property. The club objects to the untimely submission for the following reasons. 1, the submission is not timely, as the Zoning Board of Appeals made note at the public hearing in this matter commenced on April 23rd, 2019, that the Zoning Board is not accepting additional testimony and will be going directly into deliberation on the pending applications at 6:30 p.m. after the May 7th, 2019, 4:30 p.m. site visit, and made clear that the public portion of the hearing had been closed. 2, all arguments raised are either irrelevant or have already been made and discussed during the hearing. And 3, further discussion would only serve to delay the hearing and work unfairness and injustice on the applicant by surprise submittal. For all the foregoing reasons, the club requests that the Zoning Board of Appeals deny acceptance of the untimely submission, not allow it to be entered as part of the record in this hearing, and not consider the information provided in the untimely submission. Respectfully submitted on behalf of the applicants.
Thank you, and it has been submitted into our file. At this time, I am going to allow the attorney to please state it, and I will make comments afterwards.
I'm Attorney John McLaughlin from the law firm of Green Miles Lipton. I represent 8 property owners, neighbors. 3 of them are presumptive abutters, because they are abutters. If I may just address some of the issues that were raised in the objection. First off, I know of no case, no statute, no regulation, nothing that says we cannot enter anything into the record before you close the public hearing. You didn't close the public hearing. My clients just were able to afford to retain me last Friday, so what you see there is recent work, I must say. But in looking at it, I discerned many issues, some issues of fact, some issues of law, that I believe were not raised, especially not raised by the applicant in this hearing. It used to be heard. If they have any statutes, any case law, any regulation, any bylaw that backs up their objection, I'd love to respond to that. I'm sure they're going to object because I'm saying things that they really don't like and that should have been said a long time ago. There are many objections. The first one is really the submission itself. We shouldn't be guessing how many feet it is to a certain point regarding a special permit. Have you ever gone to a special permit without a plan that meets your requirements? You have specific requirements in your bylaw as to what must be supplied with a special permit application. They haven't abided by that. That's why we're guessing. Where's the line? Where's the neighbor's line? How many feet high is it? We shouldn't be doing that. My client should have brought me a plan for the special permit application, but I didn't have any plan. You all now have something over me because you know where things are. The general populace doesn't know where things are. I don't know exactly where things are, and that shouldn't be. And there's case law that I cite there that says, essentially, that if they don't provide what is required by your bylaws, you have to reject the application. You don't even have discretion. You're clearly in your discretion. After they moved for a waiver, and you rightly denied the waiver, they were arguing this is a shed, not like the shed in my backyard, near my garden. This is a shed for shooting high caliber firearms. It's not unreasonable to ask to put that on the ground someplace to see whether it's reasonable to use this shed as they are contending they're gonna have to use it at some point. So this is not a trivial thing. Because we don't have the plans, you can immediately reject it. Also, if the use of this shed is in any way involved, they should have submitted many other things. Stuff like the length of the range, the relative heights of the berms, the location of the berms, the targets, all with detailed plans and giving you far more information than they have. Take a look at it, you can come see it, and nobody else gets to see it. That's not a proper submission. And I could be wrong, I received these documents just recently, but I don't see a signed application. Is it just that I didn't get one signed, or is the application signed? I don't know if Mr. Chairman could answer that question.
I'd have to go back and review that. but I
The
don't
one that
believe
I
it's
saw
actually
was
physically
unsigned. Okay, maybe it was signed, okay. The second major objection is this. What they're asking for right now is, they're saying, we want you to let us build the upper shooting shed. And they're saying that, just consider the shed, don't consider what it's used for. Well, in a special permit, to grant a special permit, the granting of it must be in conformity and in harmony with your bylaw provisions. That's chapter 48, section 9. Clearly, it's not in conformity with your bylaw provisions, because you have already correctly and rightly determined, this board has already determined that they can't use the upper shooting area. So how could you possibly allow them to have a building for what? This isn't a shed for the garden, this is a shed for the upper shooting area. That cannot be in conformity with your bylaw. So you can reject it, because the use that is absolutely contemplated with the building is an illegal use. There is no way you can issue a special permit for an illegal use. For a building that is, it would be as if I came in here and said, I want to build a two-family in your one-family zone, because someday I'm gonna go to court and beat you and show that you're putting in too many one-family restrictions for some civil rights violation. They can't do that. Right now, the use that they are contemplating for this building is illegal. You've already determined that. So that's the second major ground. Now, in that regard, I also want to point out that I think you were right. I think this board was absolutely correct when you said that they can't use that shooting area. It is an illegal extension. It's not in conformity with chapter 48, section 6, because they've substantially increased the effect on the neighborhood. Now, I know that my sister council has argued that they're protected from all noise, and if the noise is the thing that triggers the difference in the effect on the neighborhood, then they're somehow protected. But that is not the case. Read the statute. The statute, this is the noise protection statute that's laid out in my memorandum. It's never been construed, so I can't point to any appellate case saying, you know, this is the way we read the statute. But the way I read the statute is it contemplates various numbers of ranges on a property. Because it states in the statute that you're protected from sound violations if the ordinance was passed before the range was constructed. You don't construct a piece of property. They keep referring to the property as the range, like we're cowboys, you know, like home on the range. That's not what this statute's about. This statute's about a shooting range. You can call it the range property all you want. It doesn't change the fact that the statute pertains by its very language to multiple ranges on one piece of property. Because at another point in the statute, it says you can move your range. If the range was commensurate with the property itself, if the two words meant one thing, then how could you move your property? You can't. You can move ranges within the property. And you determined that there were more than one range out there. There was an old, tiny range, and then there was this new range, this new massive 1,000-yard range that was recently constructed. That range came into effect after you passed the sound bylaw in 2006. So that is not protected. And if that range has a bad effect on the neighborhood, you cannot issue the special permit. Now, so I think you're going to win at trial in the land court. And that raises another issue, which I am admittedly confused. I've been doing land use and zoning law for many years, and I'm really confused with this remand, okay? Frequently, what happens is there might be an enforcement action that gets upheld by the ZBA, that goes up to the land court, and the land court judge would then say, send it back down to see if you can get a special permit for the use. That's precisely the way I read what happened in the land court action. the judge said, send it back down, and they were supposed to come to you seeking a special permit for the use of the 1,000-yard range. Instead, what they've done is come in here and simply ask to build a building in the hopes that they're trying to say that you were arbitrary and capricious before. So they're asking you to second guess yourself. They're asking you, build this building because we're gonna admit that we're gonna lose the land court case. Otherwise, I don't see how this can be utilized. The only way they can use this is if you guys lose the land court case. Unless, and this I don't know because it's so unclear, because I see them in their written argument arguing about how the permit that they're asking for right now can be used to use the 100-yard, the 1,000-yard range. But the application only references the word construction, and orally, I watched the videotape of applicant's presentation last time, they said, don't talk about use. Well, that's blowing hot and cold. What are they doing? Do they intend, if you issue this permit, do they intend to use it? Do they intend somehow, I saw sister council say that they're not gonna ask you for permission to use this. That was a very telling statement, I believe. She could be saying, once we get this building, we can use this. I don't know. They should clarify precisely what they are seeking and how it could ever work with what is now an illegal use. So, I mean, the main objections obviously are that they're asking you to do something that you have already determined is illegal. This building is to be used with the use that you've already determined is illegal. I think you're gonna win on your land court case. I know that there was some veiled threats of civil rights actions, but I have seen nothing that would lay out any type of case against this town or this board for a civil rights violation. I'm not an expert in that, I'll grant you that, but as far as land use and zoning goes, their whole case, or much of their case, relies on that statute. And I read that statute to talk about protecting specific gun ranges on someone's property that were in existence before you passed a bylaw in 2006 that set out noise regulations. If that was constructed as a separate and distinct range after 2006, you're perfectly within your rights to deny a special permit for use. I'm not even sure this is a special permit for use. It is so vague, it's so contradictory, it's not at all clear. And because there's no plans to look at, that makes it impossible to comprehend. It's impossible to tell whether what they propose to build is going to be safe, is going to be in conformity with your bylaws, because you can't take a building away from its use and still be in conformity with your bylaws. Your bylaws say that you have to issue a special permit if it's if it's compatible with the district. How is it compatible with the district if the use that they're asking for right now is an illegal use? How could that ever be compatible? Or if it's in conformity with the neighborhood, how can illegal use be in conformity with the neighborhood? So it is admittedly confusing, but from what I see right now, at a minimum, they haven't given you the proper items that are absolutely required by your bylaw. There's appellate case law that says you can't go forward. Not that you have even discretion, just that if they don't give it to you, you can't go forward. And my clients have had no problems with this gun club for 30 years. It's only after they've massively changed the gun club to add more gun ranges. And that's when the problems occur. So I wasn't going to speak in general against the existing shed, but without a plan, how can you even approve the existing shed? I just don't know if that's feasible. But as to the upper shooting range, there is no way I can see you issuing any type of permit, and they really have to explain what they're trying to do here and explain how they're in conformity with the land court case. You guys are parties to the land court case, this board. And the deal at the land court case was they were supposed to come back down here and they were supposed to do an application for a special permit. That would normally require a massive filing with experts, hearings on all types of things related to gun safety. Instead, they say, we're just building the building and now we're gonna go back to land court, if that's what they're saying. Or else they might be saying, we're just gonna build the building, once you give it to us, we don't need your permission to do anything else. I don't know, because they've said some things in writing that are very different than they've said orally. I hope I've set forth most of my clients' objections.
Okay, I thank you for your time.
Thank you.
I would just like to put into public record my opinion on why I've allowed this gentleman to speak this evening. at this hearing. At no time was the hearing closed from our last. We did close the meeting at that time. My objection to hearing public opinion on that date was I felt at that time we had wrapped up most of that. We have continued the hearing today along with the meeting. So I found it to be perfectly within line to accept that statement. So thank you. I did pass along a copy, I believe is the permit application, and it does not appear to be a signed copy, nor is the second one that I found here. So I don't know if that's something as well that.
I'm sure that was an oversight.
Yeah.
If what's in the packet wasn't signed, I'm sure Attorney Richardson hopefully would have ensured that a signed copy would have been there. Certainly, the ones that I've seen have not been signed.
Have not signed.
They have Granby Bow and Gun Club typed onto it. I mean, if we want, Attorney Rafelson, do you want to make sure that he's signing what's been submitted?
If it was signed and you can't find it, then we're happy to re-sign it right now.
Right, and I just want to, I just want to ensure that council is in agreement that that was what was filed.
They signed it at town with Kathy Leonard. Why don't you just go
Okay.
re-sign it right now?
Okay,
And go sign it.
yeah. Yeah, Justin, do you want to make sure that, to make sure what your client's signing is,
This was in the total packet with the application.
The other thing I've noticed, if that was the case, there's nothing on there signed from the board that says that it was reviewed and accepted for submission either, which looks like that was a requirement at the bottom of that page as well. So,
Yes, maybe the board could finish that, complete that, and
And I
accept.
just wanted you to also, I may have the attorney look at what parcels this is in reference to for the special permit.
oh, that's where the Bow and Gun Club is located.
But you need to, but the parcels that are affected are the ones we provided plans for, and they're not all affected by this. So Marshall and Sandy, if you could please make sure that they're correct.
So they are,
that, yeah.
Parcel 6.
so they are all partials C3, 4, 5, 6, 7, 9, 10, 11, and 12 as
No, the only
brought up
parcel.
at my last question of two.
So at the first meeting, as part of this hearing on the 23rd of April, it was agreed that it's only parcel 6 that has, C6, that has the shooter sheds on it. The other parcels are individual separate parcels and plots. They are not implicated in this application.
That's part of what the board, and I would bring up as a question, that obviously they are for the use of the property is going to be for the shooter shed. It's going to impact all those zones.
But the permit is to construct and to use shooter sheds. The use is existing. The use is existing, and as far as projectiles going through the air, the projectiles are land where they've always landed. They have landed since 1940 at this site. There are affidavits that have been submitted from members of this club that go back to that time period about shooting, the existence of the types of shooting and distances and locations of shooting on this property. And the only parcels that are implicated for the construction of the shooter sheds, which is the only new activity here, is the parcel C6. And that, under the bylaws, the only parcel for which information is needed is for the parcel on which the sheds are being constructed, the activity that's at issue in the permits. Now, the building inspector has not been available. He's been ill during this hearing. We did list him as a witness. We would have called him because our surveyor, the club's surveyor, made clear to us that he interviewed the building inspector about how much information about a very large parcel like C6 was necessary to be provided, where it was far, far away from the shooter sheds and had no impact on the construction, or construction of the shooter sheds would have nothing to do with these far reaches of this very large parcel. And the building inspector informed our surveyor that it is not customary for the town of Granby to require all of the details for a 100-acre parcel or a 75-acre parcel, which I believe this is something like a 75-acre parcel. And so we had planned to call him. He's been ill, but that is why it's not customary in this town to require that. And the board, contrary to our esteemed council's representation, this board does, under its own bylaws, have the ability and the discretion to waive the requirement that any particular information on a plot before you be waived. And
That is correct. That's right at the bottom. You did approach us for a waiver. Waiver was denied.
it was denied, and we're...
Information was again submitted to you of what the requirements that we were looking for
Well,
were.
If I may interject and
Yes, you may.
correct you, you can waive the requirement of the site plan, but separately you can waive the requirements of information that you judge to be unnecessary to review. So those are two separate thresholds.
Okay.
And it's outlined in the required site plan.
But we chose that all of them were required. There was no
We
waiver on our part.
We understand that you did, but we
Okay.
also understand that you did that without having visited the site, which you were able to do today, to
Yep.
see that you can't see houses, which means houses can't see you. You were able to go out on the site and see what's there, see the distance to the tree line, see the voluminous trees between these shooter sheds and any neighboring property. You were able to see all that for yourselves, and we therefore, now, here and now, renew the request that this board, based on the new information that it has from visiting the site, that it reconsider its previous decision, and that it actually waive the requirement for the kind of extensive information on the parcel at issue, which is the C6 parcel, and waive that because the information provided in proximity to the shooter sheds is sufficient. So we would ask that you reconsider based on this new information that you have given as of today, and do waive that information.
Have any board statements or questions on that one? No?
Quite truthfully, by having the site visit, probably brought more questions to my mind than assured me, because of seeing the different heights, the heights of where the long-range shed is going to be. It was much higher than I expected, so that having the topography information and the borders would have been helpful. So that was my perspective after the visit. So I wasn't necessarily moved to wanting to change a decision on the waiver, at least from my
Can we
perspective.
address the elevation for a moment? So elevation was not provided, as it seemed to be irrelevant to the impact of the shooter shed itself on the neighborhood, because the shooter shed itself, as explained last time, actually improves the impact of the existing shooting on the neighborhood by mitigating the sound.
What case study do you have to reference it to? Not a word or hearsay from another club.
Many case studies that when you add a shed and walls and a roof and sound suppression material, that is the standard method, but low-budget method to mitigate sound. And I teach at NRA range conferences around the country and meet with professionals. They're full of professionals who are there to teach about noise mitigation, environmental management, building ranges, constructing ranges, making safe ranges. And I have taught at these seminars by invitation, and I also teach how to litigate range cases for the NRA nationally too. I teach other lawyers how to do that. And I can represent that hearing these professionals, this is the low budget way where you start in terms of mitigating noise.
But
Exactly what's
what
been
I
proposed.
find, especially after the site visit, to be honest with you, with the elevation, because we don't have a buffer zone that is directly around us. I could see the luxurious trees, the beautiful, beautiful surroundings to it. I say it is very impressive. absolutely gorgeous range area, okay? I find that from a muzzle of a gun is where the sound is gonna come from, and it's already been stated by your own submission into evidence that it's pretty much, the muzzle is gonna be to the front of that building outside of it. So therefore, the burst of a gun going out, to me, is not gonna be mitigated by what's around you on top or the sides. And that's why I brought up the question of the double doors as well before, and I did like the response that there would be a potential for a sound mitigation on that as well.
Mr. Chairman, if we could address that issue before you go further, just while I can still remember, because I didn't bring my glasses and can't write it down. The sound that exists from existing shooting, which we have documented, goes back to the 1940s, from the upper area, is sound that exists today with the lawful use of this Granby Bow and Gun Club at this property. The shooter shed does not, there is no evidence that a shooter shed with sound suppression material increases noise. It's unheard of that a sound suppression material in a shooter shed would increase noise above what the noise heard from shooting without any suppression, without any walls, without any ceiling, and without any material. So independent of the elevation, the question is whether shooting out in the open from the upper firing area versus shooting from within a shed with sound suppression material, which has more impact on the neighborhood. The club is already allowed to impact the neighborhood with noise from the upper firing area. It's been shut down, and we think that's a big problem for a couple of years now, but when it's operating lawfully as it's allowed to and has since the 1940s, it's allowed to make that noise from the upper firing area, whatever elevation it is. So the question isn't about whether the noise is allowed from that elevated upper firing area. The question is whether the shooter shed is going to exacerbate the noise or make the impact on the neighborhood worse, and it will make it far better. So we submit that not only does this special permit application not have an adverse effect on the community, it has a very positive one, which this club is not required to make. They're not required to mitigate noise. They're allowed to shoot there and make all of the noise that any firearm they want to shoot up there makes by law. And if we'd like to have a precedent on that in Massachusetts, we're happy to set it, okay? Because it would help a whole lot of other ranges. If we have to go and set that precedent, we'll do that. But we prefer not to, because we don't want the club does not want the town of Granby to have to spend that kind of money. They don't want to have to spend this kind of money. They want to be a good neighbor, which is why they came forward with this permit application, so that they went above and beyond what they're required to do. They're spending money. They've lost money by being closed for 2 years. They're spending money by building a shooter shed they don't need. They're spending money by putting sound suppression material in that they don't need. They're spending money on lawyers. They haven't gone after the town for their legal expenses or their costs, and we are definitely recommending that they not do that, that they continue to be a good neighbor and get along with their own town, which they like and don't want to run up costs for. But they've gone way beyond what they're required to do legally in order to decrease the level of noise in the neighborhood. So this application not only doesn't have an adverse effect in the community and the neighborhood, it has a beneficial effect that they're not required to produce. And they're doing it as a means of trying to settle this litigation so that they have something that they're looking for, and these people who are opposing the range get something that they're looking for, and the town can be the hero and say, we made it all happen. And we're hopeful that you see that this really is a great result. And if they want to go and litigate against the club, they have a lawyer. He's a capable land use lawyer. He will go and he'll bring the litigation. He'll make whatever claims he wants, and there are typically many claims raised in these cases: noise, safety, zoning, nuisance. The list goes on. I can tell you what they are. He'll make those claims. He'll bring another counsel if he doesn't know how to make the other claims, and we'll go to war in court. But why should the town of Granby be caught up in that? Why should the taxpayers be paying for that? Why should you get yourself in the middle of that? It doesn't make sense, and we're trying to provide an elegant solution for everyone that makes things better for the neighbors, makes things better for you, makes things better for the club, and lets everybody get on with their lives so that we can go and fight in court if that's what's required.
Any other questions from the board for this hearing? No? Do you feel at this time that it is appropriate to close the hearing? Mindful to all members that if the hearing is closed, we are not allowed to bring in any more evidence, any other questioning at all. that it would only be at that time that we would then discuss it in a meeting and would be allowed to make a vote. So do you
I have one final
have a
point.
question? Yes.
Just before, there's several issues raised by opposing counsel that address this issue of whether or not the club has provided enough information. And if that's a big issue for the board, we would entertain.
Okay, you okay? Okay, go ahead. Let's
You're
get it
fine.
done. You're not gonna hit me.
Any questions or comments before?
That is correct. If you close the hearing, there will be no more questions, requests for additional information. There'll be no more comments from anybody here today. You have to be prepared with the information that you have in front of you to make a decision, and also provide a reason indicating that decision. Okay, it simply can't be an up and down vote, okay? Should be discussion so that the record would indicate the reason why the board has taken the action that it has. And it will be required to file that along with its decision in a timely manner. It should be prepared to do that if it were to act today, to do so within 14 days.
And we would ask that any motion, if it's a motion to approve, include a waiver, a decision that if maybe it's two separate motions, I'm not sure, you're the master procedure here, but if the board would need to move first to waive, to accept the information that was provided as appropriate and waive the requirement for additional information on this large site. So we would ask that there be a decision on that, so that there's a clear waiver, so that it can't be challenged by a council on appeal, so that there's a clear waiver by the board of additional information, and then a vote on approving the special permit application. If you're going to deny it, then you'll just deny it and we'll all go litigate. But if you're going to approve it, we would ask that you first waive the requirement for additional information, so that it's a nice clean vote on approving it.
Well, perhaps then, before closing the hearing, if the board wants to have a discussion on that, on the renewed kind of sub-motion, and whether or not the board wants to entertain that motion, I think it would be appropriate then to discuss that now before the closing of the hearing. Doesn't mean you have to take any more information from the applicant, the opposition, or anybody else. But so that way then, it has been addressed, at least during the hearing.
Discussion on that for potential for a waiver.
So,
I guess a motion to
clear.
reconsider the previous request of February.
The waiver for the site plan?
Okay, so so you're having a separate motion.
Because it's
I mean-
a separate subsection of that section.
Within the section.
The section is under the required site plan, 6.33.
Mhm.
There's the first paragraph that talks about waiver of the entire site plan requirement. And then at the end, after 8, it says the board may waive any information requirements that judge to be unnecessary to review a particular plan. So that's a certain portion of that, of section 6.33.
Okay.
So our request for waiver was in regards to the entire site plan, if you remember initially.
Okay.
This is a separate sub-motion, if you will, to waive if you had a few requirements that you were looking for, to waive those additional requirements.
To waive whatever information you didn't receive, to find what you have as sufficient.
Now, have you heard opposition to this new motion, if this is a new motion?
Mr. Chair, it's your meeting. You get to decide who you hear from or not hear from.
I'd like to hear from my advice on that. What do you think, so?
My thought, I am not necessarily feeling comfortable in waiving. any additional information. I just feel that the site plan needed was important.
So at this time, I would say no to your comments. So I would have to make a motion then that we need to take a vote whether or not we feel that any type of a waiver of any of the information that was required on the site plans would be accepted at this time. Do I have a second on the motion?
I'll second.
Okay. All in favor of making a waiver that they do not have to have the full set requirements that are on there, say aye.
So we're denying the
All-
waiver, right?
Well, I'm saying at that
I'm gonna
point,
be
if,
clear on the,
I'm saying if you were going to allow them to have a waiver so that they did not have to meet the full requirements, please say aye. All opposed?
pause.
So at this time, unanimous decision was made opposed to having any type of a waiver for the site plans as requested. So, again with that. So again, at this time, we still need to, if there are any questions or anything that you need to discuss at this time before a hearing is closed, because again, once the hearing is closed, we are not allowed to ask anything or receive any more. So I ask the board to please take into consideration that at this time. And if you have any questions of something that would help you formulate a decision, whether or not that vote would be taken tonight or in the future, we need to ask that questions now, please. Do we have anything?
We would ask that the board clarify on the record what it is that is missing, that you feel that you were supposed to have received, that you didn't receive for parcel C6.
I think we've addressed that over and over again with the letter that actually was submitted to you on record, and that would be, at this time I don't have it in front of me where I'd be reading it, but obviously we want a topographical, full description of all the elevations that are on the site. We had asked for any changes that were made physically to the property, which obviously would include berms and that, because topographically that would change the positioning of there. That would be your barriers for the trees, things like that, which would be your buffer zones. It would be your water formations that are on the property, such as the existing water that's right in front of the lower shooting shed and any other type of water that would be on that property.
Mr. Chairman, could you
Yes.
point to where in the regulations such requirements appear?
We asked for full topographical, and when we read at our meeting, we'd ask for that. So is there a topographical been submitted? Full site plans? And I would actually contend, I would have to find out from all the rest of the board that I disagree that the only portion or parcel of that land that is affected would be 6. I believe just by the application alone stating all of the parcels would indicate that we would need to have a full site plan of that, and that is what we have requested.
Obviously, we disagree. The bylaws make clear it's the parcel on which the activity will occur. There's no application for shooting activity. There's an application for a shed. The shooting activity is pre-existing. So we would submit that C6 is the only parcel at issue. And if we needed to clarify that, it's been clarified at this public hearing. If we need to do it in writing and cross those out and initial those other parcels, we can do it right here as well. But we're just trying to find a way to avoid litigation, and this is something that can be done here now to clarify for the record that the parcel affected, which is all your bylaws talk about, they don't talk about the whole property of what's owned by the applicant. The other parcels aren't at issue, buildings on the property, the clubhouse, all these things aren't at issue, water on other parcels is not at issue. So we would, again, strongly encourage this board to find a way to avoid litigation by, if we need to cross out the other parcels at this time and initial it, we'll do it. And again, we would ask that, in light of that new bit of information right now, that this board reconsider its vote on what information is necessary for these sheds. Because there will be litigation, definitely. The question is whether the town is going to be caught up in that litigation, and we're trying to find.
I can appreciate you to keep reminding us of that, but it almost sounds of intimidation, and
Well,
I
we're not
prefer
trying to-
not to keep hearing of litigation.
But we're not trying to
We are
intimidate.
trying to just go by what is in front
Right.
of us for evidence.
Right.
We have not violated anybody's amendment rights, we have not tried to strip anything away, and I please ask that's not a good course
So
of action
again,
to keep
we're
referring
not
to
trying
litigation.
Threatening, we're being threatened, and we're trying to extricate the town from what we're caught up in. We can't get out of it, but we're just trying to find an elegant way for you guys to get out of it, that's all.
Okay. Which way would you like to proceed for this hearing?
Well, I think it's time. Would you like to close the
Close.
hearing? Motion to close the hearing?
Knowing what it means.
Or do we,
Well,
wait.
Please?
Please stand up, Justin.
It is up to the chair as to whether or not he wants to,
At this time, we are making a motion to close this hearing.
We're gonna
We
withdraw.
I mean, a second.
withdraw our application. The applicant withdraws its application.
perhaps, Attorney Dean, before you do that, I believe under 48, Section 16, if you withdraw it without requesting the board's permission, it's with prejudice, which means then a two-year moratorium is in place.
We're asking for the board's permission.
Okay.
That was-
Okay.
That's why you have co-counsel.
Okay.
If there's issues the board wants addressed, they can be addressed.
Right.
If that's what's holding up the application.
We've tried to get clear information about what was required and why all along in this process because of the litigation. Communications are very stilted and difficult to get that information. We just have a clear statement from the chairman about what he's looking for. And we asked for the board's permission to allow us to withdraw it and resubmit it with the information.
I believe we were already done at that time in making a motion to close. I don't know what my...
Well, I would, in terms of strictly procedural, Mr. Chairman, that motion was not seconded. In the meantime, there was a oral motion put forward. I would probably, Attorney Rafelson would like something in writing indicating like handwritten if we have to. Requesting to withdraw this application. I believe it's 4860. I'm just going to have to try.
It is, it's 48, chapter 48, section 16. There's a 2-year moratorium unless you decide that they can give you grounds to waive the moratorium. In light of the fact that ages ago, they denied their waiver, I think if there was ever a case to deny the request for the moratorium, this is a good one, because they should have done something when you denied the waiver before.
Well, and we mentioned multiple times how costly it was to get all of this information and to come up with it all at one time, quite exorbitant. And we're not trying to have the board, we're not trying to hamstring the board here. We want to put forth everything we can within reason. And obviously the application, we needed to put in as soon as possible, given the pendency of the court hearing, or the court case, and the fact that the judge in the court case was looking for a date certain for application. Coming up with the money to do all of this is for an entire parcel. And we were just looking for clarification of which parcels, which affected parcels the zoning board was looking for us to get surveyed. Which was never made clear by the building inspector. The building inspector told us only the parcel affected with the building.
Attorney Rafelson, do you mind if I put at the end of this pursuant to Mass General Laws, Chapter 48, Section 16?
May I take a picture of it with my phone on the bottom?
Certainly. And this would need to be done by majority vote.
So I'm making a motion.
There's a motion before you to withdraw. they are asking under 40A, Section 16, to withdraw their application without prejudice. Essentially what that means, Mr. Chairperson, is that while under 40A 16, if they were to withdraw it unilaterally at this point, after the first publication of the public hearing, they would not be able to bring this particular application back within 2 years. Now, that's what the statute says. There are other practical realities of that. That certainly, in my opinion, should the board not allow that withdrawal, the board would then go on to their vote. And yes, we would most likely end up in litigation for at least that period of time. So what I'm hearing from council is that they would like the opportunity to withdraw this particular application. I think sensing from the comments from the board that certainly the required site plans under 6.33 that they hear the board right now, and that they hopefully will be working with the board with the new application. Perhaps council should be in touch regarding that application in terms of including Attorney Coyle, based upon who represents the board in the land court case, what the remand from the court, for the whole reason why we've been here, what we are to have to be addressing, and what the ZBA, the board, what they want to see in terms of the required site plans. Perhaps of those 8 items that are there, again, we'll have to see the application, but certainly a site plan is required. The bylaws state what those are. I'm familiar with some of the case law that Attorney McLaughlin has mentioned. It does seem to fall within there, but if what the applicant wants to do is basically, to a certain degree, I don't want to say start over, but understanding where this board is coming from in order to judiciously move this application along while the land court waits for us, that may make sense.
If I could be heard? Yes. 48, Section 16 also has another provision, Mr. Chairman. If they come back in with a significantly different application within the 2-year period, so long as they can show there's been a change in one of the factors that pertained to your, what would have pertained to the denial, they can be able to come back forward with a supermajority vote of both the planning board and the zoning board. So they have other options, I believe. I've never had that situation occur, but I believe that's the language of the statute, something to that effect.
Okay, so is this board in understanding of what we'd be voting for, whether to accept this application and withdraw, or move to withdraw their application?
Without prejudice.
Without prejudice.
Without prejudice. Do you understand, or do you have any other questions?
I understand.
Okay. Okay, so I need to make a motion for this to be accepted. This have to be unanimous?
It doesn't have to be unanimous.
Oh, this one doesn't have to be
This
unanimous.
is
Okay.
majority. So, 3.
3 out of 4. So, all in favor at this time of accepting this application withdrawal, please raise your hand.
Without prejudice.
Without prejudice, please raise your hand. All opposed? Okay. So at this time, the motion has failed for that to pass. Do you want to copy this, or?
We'll need a copy.
Okay, so at this time, I believe we then would continue to vote. Do I have any other questions or anything before we actually close the hearing? Or make a motion to? This time I would make a motion to close this hearing.
I second it.
All in favor?
Aye.
The hearing on this issue is closed at this time. This time I open it up to the board if we have anything to discuss about this topic. Help us formulate when we would like to take a vote or how to formulate that. Remember that we are not allowed to ask any questions of our attorney or any of the members here this evening. Do you have any discussion that you would like to make at this time? No? Have any discussion of whether we need to review any of the information or take time to process this on our own before we would come to any type of a decision? Do we need to think about that?
I think we had a lot to think about.
We give a lot. Okay. Do you have any idea when we would like to meet again for a meeting? Okay, there's a suggestion.
Now that the hearing's been closed. The board technically has 90 days from this point to meet in public again, again with all the posting requirements, to deliberate in public. I do not recommend putting this out, months or weeks. I think this is a matter, again, this is just, I guess me speaking, it has to be timely. This is a matter that is currently in litigation. There are a number of interested parties that I'm sure will have to prepare for whatever next steps come, depending on the decision of the board. So I would recommend that while the statute says 90 days, the board should find enough time to review the materials and to be able to deliberate them intelligently, but should do so quickly.
Any suggestions from any of the board members as to a time frame as when we'd like to meet again? What availability would be?
I just have to check my calendar, but I think what we need to do is just to be able to work with the town, so for proper posting of the meeting.
And
Go ahead.
And also, just housekeeping, I don't know that this room is available either. I know that that was a problem. Fortunately, we were able to secure this room. We had to, at the last meeting, actually set it for a time certain. So we couldn't, but I suppose the board can preliminarily set a date and time, but that the actual posting will be the legal notice.
Okay.
A couple weeks out? Or couple weeks?
I would say 2 weeks out, if possible.
So possibly the 21st?
It is, yes, it is.
Yeah,
Yep.
so,
That's election day, yeah.
yeah. Is Memorial Day the 27th?
It is.
Yes, yeah.
Tuesday the 28th?
Day after Memorial Day, the 28th.
Memorial Day will be on Monday,
Right.
7th, yeah.
Just for availability. 28th?
Anthony?
28th? 6 o'clock? Yeah. And then a location to be confirmed?
determined as
Yeah.
availability. So does that have to be a
Yeah.
motion or you just-
I think you could, unlike the continuance of the hearing, I think we can preliminarily set it for May 28th, subject to availability, time to be determined. I'm sure Ms. Leonard will, once we're able to figure out the logistics of time and place. I don't know how much more of a crowd we're going to have, since there won't be, and whether or not this room is going to be needed by other boards that perhaps are going to have a bigger audience. So we could preliminarily set it for May 28th at whatever time.
So preliminarily, we are going to have our next meeting on this subject on May 28th, tentatively 6 p.m. Location to be determined by availability of the town. At this time, does any board member have anything else, other housekeeping thing? No. Okay. At this time, I make a motion to close this meeting.
Aye.
Second.
All in favor?
All in favor?
Aye.
Aye, unanimous. This meeting is hereby closed at 7:34